I'm Cynthia Rowland, and this is episode 99 of EO Radio Show. Today's episode introduces several critical compliance topics relevant to international grant making by U.S. public charities and private foundations. These are the antiterrorism rules, income tax withholding rules, and special rules for private foundations. These basics episodes touch on the rules for U.S. charitable organizations that make grants to organizations or individuals not resident in the United States. Grantmakers need to be aware of a couple of general requirements, and private foundations also have an extra set of concerns in order to be sure that the expenditure outside the United States is not penalized as a taxable expenditure. The private foundation grantmakers also want to be sure that the expenditure does count towards its minimum distribution requirement. I'll start off this series with an episode focused on introducing the Patriot Act rules that apply to all grants, international and domestic. In the next episode in this series, I'll provide a brief overview of the income tax withholding rules that apply to payments for services that come into play when making a grant to an international organization that may provide some services in the United States. And then the third installment of this series will focus specifically on the special private foundation rules, expenditure responsibility, equivalency determination, and other techniques used by private foundations that make grants to international organizations. Welcome to the EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Today's episode is the first of a three-part series introducing key topics for charities and foundations that make grants to international organizations. First up is a primer on anti-terrorism best practices. These are not new rules, and most grant makers will have seen a standard provision in their form grant agreement that prohibits grant funds from being used to support violent or terrorist activities. This episode fills out and addresses the best practices for grant makers going beyond this form language in the grant agreement. These issues took center stage 2 decades ago in the aftermath of 9/11. Although revocation of tax-exempt status is one possible consequence of funding violence, other potential consequences include civil, criminal, and financial liability under the Patriot Act and the Presidential Executive Order 13224. That's 13224. Violations of the Patriot Act can give rise to not only criminal penalties, but also asset blocking and exposure to civil liability to victims injured by the terrorists. While historically terrorism has often been thought of as an international issue, the Patriot Act and Executive Order 13224 apply to domestic terrorism and international as well. Mere organization as a nonprofit entity or recognition as a tax-exempt entity described in Internal Revenue Code Section 501c3 doesn't provide any protection against the possible consequences of inadvertently funding an organization with terrorist connections. So let's take a close look at internal processes that can help grant makers to assess the risk, if any, of their grant-making activities. The executive order, as I mentioned, has some stiff penalties for nonprofits that violate these rules. The Patriot Act allows criminal and civil actions if the organization provides what's known as material support for listed persons, or if the organization is otherwise associated with listed persons or those persons determined by the executive branch, even if not listed as terrorists. Material support or resources includes currency, monetary instruments or financial securities, and certainly includes funds distributed as grants to grantees through which impermissible persons are paid. So the key document for grant makers to be aware of is a publication by the United States Department of Treasury known as the Antiterrorist Financing Guidelines, Voluntary Best Practices for U.S.-Based Charities. These are known as the Voluntary Guidelines. This document provides a roadmap for charities to employ in designing their procedures, and it has 4 parts. They are, first, good governance of the grant maker, disclosure and transparency in governance and finances of the grant maker, appropriate financial practices and accountability for the grant-making organization, And then finally, anti-terrorist financing procedures for assessing the grantees. So I want to focus here on this part 4, the anti-terrorist financing procedures. This is because the first 3 parts of the best practices are things that apply to the nonprofit grantmaker itself. And these are the basic rules that apply to all nonprofits. So there's nothing really new there. But what's really important for protecting against inadvertently funding terrorist or violent activities is in part 4 of these anti-terrorist financing procedures that are part of the voluntary guidelines. So let's focus on that. These anti-terrorist financing procedures in part 4 cover 3 main categories. First, collecting information from the prospective grantee. Second, what I'll call a do your own research section. And third, looking at the numbers. So let's start with collecting the information from the grantee. The voluntary guidelines suggest that the charity should collect all of the following basic information about a foreign recipient organization. Number 1, the foreign recipient organization's name in English, in the language of origin, and any acronym or other names used to identify the foreign recipient organization. Number 2, the jurisdictions in which the foreign recipient organization maintains a physical presence. 3, the jurisdiction in which the foreign recipient organization is incorporated or formed. Number 4, the address and phone number of any place of business of the foreign recipient organization. 5, the principal purpose of the organization, including a detailed report of the recipient's projects and goals. Number 6, the names and addresses of organizations to which the foreign recipient currently provides or proposes to provide funding, services, or material support to the extent it can be known. Number 7, the names and addresses of any subcontracting organizations used by the foreign recipient organization. Number 8, copies of any public filings or releases made by the recipient, including its most recent official registry documents, annual reports, and annual filings with the pertinent government as applicable. And number 9, the foreign recipient organization's existing sources of income, such as government grants, private endowments, and commercial activities. And many of these names and details are the ones that will need to be run through the list checking on the OFAC site. So that's why we need to collect so many different pieces of information beyond just the name of the grantee. So then the second part of the best practices for the foreign grantee is what I'll call the do your own research set of questions. And this part of the best practices suggests that the charity should conduct basic independent review of the potential recipient organization. And here's the things that they suggest as possible appropriate review activities. First, the grantor should be able to demonstrate that it conducted a reasonable search of public information, including information available through the internet, to determine whether the foreign recipient organization is or has been implicated in any questionable activities. Second, the grantor should be able to demonstrate that it verified that the foreign recipient organization and all those names and details that I mentioned in the first part do not appear on any list of the U.S. government, the United Nations, or the European Union identifying it as having links to terrorist activities or to money laundering. The charity should consult the Department of Treasury's OFAC Specially Designated Nationals List. That's the Treasury's Office of Foreign Assets Control, which has a list called the Specially Designated Nationals. And this list identifies entities designated by the U.S. government as foreign terrorist organizations or as supporters of terrorism. The charity also should consult the U.S. government's terrorist exclusion list maintained by the Department of Justice and the list issued by the United Nations under the UN Security Council resolutions, and the list promulgated by the European Union under its regulations, and any other official list available to the charity. There is commercially available software that the organizations can use for this purpose. The third part of do your own research is that the grantors should investigate key staff and obtain their full name in English, the language of origin, and any acronym or other names used, as well as the nationality, citizenship, current country of residence, place and date of birth for key staff at the foreign recipient organization's principal place of business, such as board members, and senior employees at the recipient's other locations. The charity should run these names as well through the public databases and compared to the lists published by OFAC. And the fourth part of this segment is that the grantor should require the foreign recipient organization to certify that they do not employ or deal with any entities or individuals on the lists referred to above, or with any entities or individuals known to the foreign recipient organization to support terrorism, And this last part is one of the drivers for that form language in your grant agreements. Sometimes that form language is very detailed and does require language akin to this certification mentioned. Other times we use a very short form that simply says that the grantee will not use the funds for violent or terrorist activities. And that really kind of depends on what the grant is being made for, what the country involved is, and, well, the risk that the funds might be used for violent or terrorist activities. Obviously, it's a different risk if you're providing disaster relief in a country where there has been active terrorism. That might require the longer detailed certification as compared to a grant to a foreign university for research in some particular area. The risks might be different, so the language in the grant agreement can be different. Okay, so the third part of the voluntary guidelines is the look at the numbers section in my summary. And for this part, the voluntary guidelines suggest that the grantor should review the financial operations of the foreign recipient organization. So here, the guidelines suggest that the charity should determine the identity of the financial institutions with which the foreign recipient organization maintains accounts. Depending on the size of the grant to be made, the charity may seek bank references and determine whether the financial institution is a shell bank, is operating under an offshore license, is licensed in a jurisdiction that has been determined to be non-cooperative in the international fight against money laundering, whether that financial institution is licensed in a jurisdiction that's been designated by the U.S. Secretary of the Treasury to be a primary money laundering concern, or whether it's licensed in a jurisdiction that lacks adequate anti-money laundering controls and regulatory oversight. So that's the know your banker step of this financial operations review. The charity should also require periodic reports from the recipient organization on its operational activities and the use of the dispersed funds. The charity should require the foreign recipient organization to undertake reasonable steps to ensure that the funds provided by the charity aren't ultimately distributed to terrorist organizations. Periodically, the foreign recipient organization should report to the charity of the steps it has taken to meet this goal. And then the fourth part of this is that the charity should perform routine on-site audits of foreign recipient organizations whenever possible, consistent with the size of the disbursement and the cost of the audit. Now, in summary, a lot of these procedures are things that thoughtful grant makers do anyway. So these guidelines are fundamentally practical approaches that, if followed by grant makers, will make it unlikely that they will inadvertently fund terrorist activities. And the regulators recognize that reasonable inquiry is a risk-based approach. A small grant to a well-known international organization does not require the same level of diligence as a $1 million grant to a locally governed organization in a country known to harbor bad actors, even if the U.S. organization is intending to provide humanitarian aid following a national disaster or something like that. In summary, reasonable inquiry into the potential grantee's governance and financial transparency, list checking, a written grant agreement, and specific grant limitations that prohibit use of the funds to fund violent or terrorist activities will go a long way to protecting the well-intentioned grantor from inadvertently falling into a bad situation. So that's all for this episode. Be sure to check the show notes for links to the resources I've mentioned today. Also, Farella, Braun, and Martel has a YouTube channel, and the nonprofit playlists for the EO Radio Show podcast organize all the past episodes to make it easy to find information on topics relevant to you. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun, and Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.